her to take us to court, or told us to take her to court, excuse me.
Okay. Ms. Morris?
Yes, Your Honor. So after the clean, I did respond the same day that I was unhappy. She didn't request the payment until like a week later. We had family in town, we got sick, and I did say that I did make the payment, which Zelle did mess up, and it did not, my bank, for some reason did not send that over. I did try to make the payment, and then I was just like, you know what? I don't agree with what had happened. Like there was no, I don't know. There was just no, like, no offer to like fix it. And so I was a little bit frustrated.
Okay. So, Ms. McGee, explain to the court what's going on here.
Yes, Your Honor. Give me one moment, please. I will be referring to some notes I have written down so that I can keep everything as organized as possible. I wanted to say thank you for your time. I do apologize. I know this may seem like a petty matter, only a few $100s, but it was more about the principle.
There's nothing petty. That's what we're here for.
I appreciate you and the court and their staff. So here are the facts of the case that legally hold the client responsible to the payment and late fees that we have added. Client hired us for December 23rd, right before Christmas. She agreed to a legally binding contract. All of this is given to you, the policy sheet in the screenshots to peruse at your leisure. She hired us at $47 per hour. And there was an issue with the floors still being sticky when Monica was done cleaning the house. The client was present during the cleaning. The client was present at the end when Monica cleaned the floors. And the client did have the opportunity to have Monica fix the floors. And she claimed that she was unable to do that. The rest of the home was perfect. There were no issues. Client said so herself. When the client did bring the issue to our attention on the same day of cleaning, it was right before Christmas. You know, it wasn't on my huge to-do list, was enjoying the holidays, didn't want to bother her, etc., which is why I didn't reach out until a week later. I did offer her the $20 discount, which is standard for discrepancies. I'd like to pause and say that looking back now, in retrospect, I do see, and we have altered the way that we handle a lot of things since we have begun filing against people doing this to us, which has stopped the issue almost altogether once word got around that we were doing that. But we have realized that $20 may have not been enough of a discount for all of the floors having to be remopped by Miss Mars. And I do recognize that. When I offered her the $20 discount, she accepted happily and did not have any kind of remark against the amount that we were giving her off the clean. Legally, that was technically her moment and chance to say, you know what, Annie, which is my name that I go by for safety purposes. The name of the business is Annie's Cleaning Services. She said, you know, if she would have said, Annie, I don't really feel like $20 is fair. You know, I more so feel like $40 is fair, or $50, or could somebody come back out to re-clean? That did not take place. She agreed to the $20, which is in the policy sheet that she agreed to in the screenshots there, and then began to ask me for payment information, which was rendered to her. She then claimed that she sent the payment. People do this all the time. I've been in business for 6 years. We've serviced over 20,000 clients. I have 5 locations. So I've seen and heard it all. And she claimed to have sent the payment. And once I asked her to send proof, a screenshot that she had sent the payment, she then said that she couldn't fabricate that. She was not able to give a screenshot because even if she had tried to send it through Zelle and they canceled it, Zelle records that. So she would have been able to show that she had in fact attempted to make the payment. So once she began to lie about that, etc., later on in the conversation, I was not lenient and I was not willing to do more than a $20 discount once she brought up that she felt that wasn't fair because she was being dishonest, lying, and playing games. So when I confronted her about that, she said that, you know, she had sent it, blah, 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 etc. And we told her, you know, we have a policy on the policy sheet that says there's a $30 a day late fee we have almost never enforced a late fee in the 6 years that we've been in business unless the client refuses to make payment. That is simply to hold people accountable in instances like this and have some kind of, common ground there. So
what started as a disagreement over sticky floors has now turned into a much larger legal dispute. The cleaning company insists the customer accepted a discount and then refused to pay, while the customer argues the work was never properly corrected. At this point, the judge isn't deciding who is more upset. He's focused on one question: did the agreement between both sides create a legal obligation to pay?
I told her, you need to make the payment or I'm going to, assess the late fees, etc. And she was ignoring me. So then I did tell her that I was going to put out a warrant for her arrest, that I was going to file criminal charges against her, which is something that we typically do, but the police have not been helpful. So we have, well, no, excuse me, I don't want to say that. They have refused to press criminal charges. I apologize. And so we're no longer going to take that route. Everything is going to be civil. But I did at that time tell her, because that's what we were doing, that I was going to file criminal charges because it is a theft of service, for an outright payment refusal, etc. And she told us in another screenshot that you don't have, that I can send in the chat here, that I forgot, I apologize, that there were really hot police officers in the jail and that she was happy to go sit in jail and that she was not going to make her $300 payment and to take her to court, et cetera, et cetera. And another thing is that she did include in her defense is that we called her employer. I was trying to get an additional address, which is not what I said in the messages because I was upset. But I did call her employer trying to get more information, etc., which at the time we did not realize was not okay. We had a collection company before that we are no longer with who did that. They reached out to the employers. They did that exact same thing in the state of Texas. And therefore, I thought that that was an okay thing as an attempt to collect a debt. It's been brought to my attention that that is not okay, and we are no longer doing that. So we are now in compliance with that. And I just want to let you know because she brought that up. Another thing that she brought up in her defense when we were messaging is that we have a lot of negative reviews. And so I'm only going to say this statement in response to that. And I'm almost finished, I promise. I just wanted to get all the facts out there. She put on there that we have a bunch of negative reviews that say similar things, etc. We have serviced, which I can provide evidence of if needed, over 20,000 clients in the last 6 years amongst our 5 locations, me solely alone with a little bit of help from an office manager. And I make a decent living, and I am only able to do that because I pay these women between $25 and $30 per hour, and we take care of the business. So when people leave reviews, it is an attempt to harm the business. Most of them are not factual. I do respond to every single one of them. A lot of them are very similar to this case. To outright refuse to make a payment over one mistake that's ridiculous. And the policy sheet is to protect us from people like Miss Mars. It is my belief that she never had any intention of making the payment, which is why she went back and forth and was playing games about it. Almost done. And then a few weeks after that, I did tell her I was going to be filing in court, etc. She then had a woman call me and impersonate an attorney. And the woman claimed that if we sued Christine, that she was an attorney and that she was going to sue us for $13,000 and that it was because we damaged her floors. So then I told her I can provide evidence that we did not damage the floors, that we have the after photos and videos that the floors are not damaged. They were just sticky. She then shifted her lie and said, oh no, it was the baseboards. And I said, what do you mean? She said she took her vacuum cleaner and was banging it all up against all the baseboards in the house. And all the baseboards, Your Honor, in a 3,000 square foot home needed to be replaced. And that was $13,000. So she definitely, I'm not sure why she did that. That was really weird. And then the last thing is, we did, and I can provide the screenshot in the chat. We did do everything we possibly could to get Christine to make any type of payment. I asked her, I said, before I go to court, I just want to, ask, are you willing to make any kind of payment, to not waste you guys' time, the resources, etc., the court. And she said, nope, take me to court. So she wasn't even willing to pay anything. But at the beginning, she accepted the $20 discount and then refused to make payment after lying and claiming that she had made payment. So the bottom line is she agreed to these policies, and I upheld the policies by law and offered her a $20 discount. And as I stated, had she come to me and said, you know what, I don't feel like that's fair, I was willing to negotiate that and, maybe give her a little bit more of a discount. But after she began lying, et cetera, and playing games, I'm no longer willing to do that. So I am asking that she pays the entire $320, which is the original payment, plus $210 in late fees for $30 a day for 1 week, plus the court costs, plus the 6.75% statutory interest.
Anything else, ma'am?
No, sir. Thank you, Your Honor.
Ms. Morris, do you have any questions of Ms. McGee?
No, sir, I do
You
not.
have to ask questions? Okay, so in reference to your defense, what do you wish to present to the court?
So I do have a screenshot of the Zelle being down, so I was unable to send that payment. I'm not sure how to get that into you. I completely forgot to add that in with the documents.
Do you have on your computer where you can share the screen, ma'am?
I don't. It's on my phone.
Okay.
I can hold my phone up. I don't know if that would work or.
And that's a little bit improper.
I'm so sorry. I apologize.
I'll tell you what we will do. I'm going to have one of my clerks accept an email from you on that. We'll attach it to the case and then we'll share the screen in the interest of justice on your behalf, your defense, to allow Ms. McGee to see that document. So which clerk would like this to start with getting that document sent to the court real quick?
Your Honor, may I ask what the
Hold on, Ms.
is?
McGee.
Oh, sorry.
Hold on. Thank you.
I apologize.
She can send it to jp2@jocotx.org.
I'm sorry, could you repeat that?
jp2@jocotx.org.
Ms. Ashley, when we get that, if you'll go ahead and just put it on the share screen real quick, just so that Ms. McGee can see that. In reference to your motion, I guess you're objecting to the relevance of it, is that you brought it up during your testimony and presentation of your case, so I'm giving her the opportunity to respond.
Okay, I agree. Yes, sir.
Thank you, ma'am.
Okay, I have that sent over.
It hasn't come across yet, so,
Just want to get it.
okay.
Sorry, excuse me.
Thank you, ma'am. Ladies, what my chief clerk is putting on the screen right now is the email that Ms. Morris just sent to the court.
Thank you, Miss Ashley. This doesn't have a timestamp, a date, etc.
Thank you, ma'am.
No, there's not a date.
Date or timestamp on that. So Ms. Morris, can you give me any kind of predicate that was taken on the date in question?
I just screenshot it and I didn't send it because immediately after I was like, I sent it, she started with the threats, and so I knew she wasn't going to believe me anyway, so I didn't think to timestamp it or anything.
Okay. Do you have an Apple or do you have an Android?
An Apple, sir.
Okay. So in your Apple photos, if you go to your screenshot, on your library and go to screenshots, it will give you, and scroll in there, it will give you a date and time that that was taken.
Let me go back to it.
And, or even if you just look at the picture and just kind of scroll up with it, on the bottom, it will show you a date that the picture was attached to your library.
So I did just re-screenshot it from my husband, so from our text messages, so it just shows today. That's fine. We can just remove that. It's okay.
All right, thank you, Miss Ashley. All right, go ahead and continue, Miss Morris.
So I'm so sorry. I was trying to go through my let me get to the So, I mean, it was just honestly a lot of back and forth. The referrals to her asking me what I felt was a payment to be like for her to consider. She said that the officer was asking for that, so I did ask her for the officer to call and request that information for me. I was willing to discuss that with an officer because I just felt like communication with her at that point was just no longer productive.
Okay.
I mean, I do live in a 3,400 square foot home. Like it was every single floor. I didn't take a video of the whole floor. Just where I had walked through. So I was at work at the time that the cleaner was there. The cleaner did have me do a walkthrough, but it was before she mopped the floors. There was actually still dust piles on the floor from where she had swept. So she had not mopped them yet, and I got she finished I think around 3:30 or 4. I got off work at 5:30, and then I started walking through my home, and the floors were very, very sticky and very dirty, which I pointed out in the video, which I wasn't able to upload the video to y'all, so I did grab screenshots from the video.
Okay. Did you submit those videos to the court?
I wasn't able to submit the video. I did submit screenshots.
Okay. Are you chewing gum, ma'am?
It's a cough drop, sir. I apologize. I have a cold. I can spit it out if you would like.
Just a little distracting. All right. Go ahead and continue with your defense, please.
She was just being very aggressive, and I just felt really threatened, and I just at that point I just no longer wanted to have contact with her. I just had preferred to, go through the courts or go through the officers to get this taken care of. I know that's kind of wasting time and all the things, but it was just I felt very threatened.
Okay.
And I actually did end up losing my job in January. They told me that it was due to not enough work. However they wanted to put it. I was not aware that she actually did proceed with calling my job.
Anything else, Ms. Morris?
No, Your Honor.
Okay. Ms. McGee, do you have any questions of Ms. Morris?
Oh, I
No.
apologize. Do you have a response?
No, do you have any questions you want to ask Ms. Morris, ma'am?
Oh, no, sir. No, Your Honor.
Right. Anything else, Ms. Morris? You rest your case.
I rest, Your Honor.
Thank you. Ms. McGee, rebuttal, anything else you wish to add to the court case that's been presented to the court today?
Yes, just in response to what she said, I don't mean this in a rude way or anything, just legality wise, everything that she just said for the most part is pretty irrelevant to the fact that she legally owes the money. She's failing to realize and admit that the only reason the conversation went towards threats that were completely legal. Nobody was threatening to go to her home or harm her. We were threatening to have her arrested, which if the police would have said that they agreed with it, she would have been. And so what she stated doesn't have anything to do with the actual legality of her owing the money. And the only reason that
Now the case shifts from emotional arguments to actual evidence. Both sides are making serious claims, but the judge keeps bringing the discussion back to documents, screenshots, and the original agreement. In civil court, opinions alone usually aren't enough. The party with the stronger evidence and clearer documentation often has the advantage, regardless of how heated the dispute becomes.
it went that way, like I said, is because she was refusing to make payment. I do not believe that the screenshot was from that day. You can tell, I encourage you, Your Honor, please, if you have a moment to read the screenshots, read through the messages, you can see through not only the messages, but what she was putting on Facebook, that the client was trying to cause drama. The client was playing games. The client did not really feel that it was justified for her to not make the payment.
I don't want drama in my court, ma'am. I'm
Well,
not
I'm just trying to explain, like a point of view that she continued to go on even after we stopped messaging her and was trying to do things on Facebook, etc., showing she was not afraid in any way, shape, or form. She continued to try and antagonize us by having that woman call us and threaten us if we did sue her.
Thank you. Anything else, ma'am?
No, Your Honor. I apologize. Thank you.
Ms. Morris? Anything else?
No, Your Honor.
Thank you. So Ms. Morris, in closing, before I make a decision on this case today, why do you feel you're not responsible for the $320 of the initial services for cleaning and the $210 of late fees in reference to failure to pay this services that was provided to you by Annie's Cleaning Services?
Your Honor, I don't dispute that I do owe some form of payment, but I don't agree that I owe the full 320. In responding to the late fees, I did dispute this immediately. So I don't believe that I should be responsible for the late fees. She didn't offer to come back and fix the problem. Like, I had to go out and spend the money. At that time, we had just been living in the home for about 5 months, and we had been using our regular cleaning lady that was coming, that we had used from the previous owners. She wasn't able to get there for the week of Christmas we were hosting, so I didn't have the cleaning supplies, so I did go out and buy those. And so I don't dispute that I owe some, but I don't feel like I should owe the complete 320, because that was 3,000 square foot worth of floors to re-clean, but she didn't offer to refix it. She didn't offer to discount more than 20. In retrospect, I should have realized that that was because of the previous claims that they have had from other people. I didn't expect there to be an issue.
All right. Ms. McGee?
My final statement would just be that we did try to do everything we could to work things out with the client without having to get to this place. And then the final thing is the late fees are being assigned because she refused to make payment. So once she refused to make payment, from that day forward, she then began accumulating the late fees. So it's not while we were going back and forth. It's a week worth of late fees from her refusing to make the payment. Thank you, Your Honor.
Thank you, ma'am. Just bear with me as I look over policies.
Of course.
In fact, ladies, I'm going to take a short recess. It's going to take me a minute to read through a couple of things here. I'll be right back with you. Just take a moment. If y'all want to mute yourself, you can.
Sure.
Thank you.
Take your time. Thank you, Your Honor.
Ms. Morris, you get something to drink.
Thank you.
Okay. So I'm looking at the documents you attached, and the reason I want to take a short recess because there's a lot of them here. I was kind of looking through them as you were going through, but I wanted to just go back and look at a couple things in particular. I showed the cleaning policy that you spoke about. Is this your policy that you send to all clients?
Yes, sir.
Okay. And you spoke, you said something about a contract?
We consider the policy a contract. It says at the bottom that this is a legally binding agreement.
Okay.
So in the eyes of the law, I do believe that is considered a contract, a written contract, because they say I agree to these policies, which she did state.
Okay.
We have since edited the policies to help avoid having to waste you guys' time, and we're now charging a $1,000 penalty for any kind of payment refusal, and that has pretty much cleared up the issue. I have not had a payment refusal in 3 to 4 months.
But on the bottom of this, it says by securing a slot on Annie's cleaning schedule, you agree to the above policies. Please understand these are in place. Protect yourselves, or cleaning team, and Annie's Cleaning Services LLC. So where does it show that it's a binding contract? It's just a policy.
I think we edited the verbiage after we were having these issues. So I guess,
Where's the original one then, ma'am?
no, that is the original.
Okay.
What I'm
So
saying is
this is what
Go
Ms.
ahead.
Morris agreed to at the time that she went to
Yes,
your.
sir. She agreed to those policies. That's in the screenshot of her saying, I agree to these policies.
Okay. All right. Thank you. I'll be right back with you.
Thank you, Your Honor.
Yes, sir, Your Honor.
All right. Ms. Morris, in reference to Texas law, that if a person does agree to something, either in writing such as this, not being an actual contract, but it's a policy that you agree to for those services. So it makes it a binding contract and an agreement under Texas law. Annie's Cleaning Services and LLC, under the Secretary of State's guidance of the business to operate within the state of Texas. And they do set up certain procedures reference to their services and what they are. And that's why she put out this policy. In reference to the policy, anything that is disputed, they do have the right to try to correct it and offer discounts of that nature to the bill. In this particular case, it is the belief of this court that there might have been some issues, but under Texas law, there are services that were rendered. The dispute kind of came, she said situation, which evolved to where we're at in court today. And Annie's Cleaning Service does have the right for relief under the services that they provided of the $530.00 with all court cost service fee and the 6.75% post judgment from today's date until paid in full under Texas law. So if you do remit payment to them, Annie, or Ms. Carrington or Ms. McGee, if you'll notify the court that judgment's been satisfied, you've been reimbursed the monies that's owed with the court costs, so we can release any judgments against Ms. March as soon as possible. Okay.
Yes, Your Honor. So may I just ask one question for my own clarity? Can you just, I just want to clarify that she'll have to pay the $530 as well as what I paid to file this motion?
Yes, ma'am.
Okay, thank you, Your Honor. I apologize. Just wanted to clarify. I appreciate your time today.
That amount will be in the judgment that you're about to receive. Okay.
Thank you, Your Honor.
All right. Any other questions, please?
Yes, sir. Am I able to make that payment via money order via certified mail?
Ms. McGee, how would you like for her to take care of the?
No, sir. The payment needs to be made by either Venmo or Zelle or credit or debit, as stated in the original policies that she agreed to. We do not accept money order, etc.
Well, it's a little bit different here, but.
Okay.
She wants, instead of just doing Zelle or anything like that, she wants to get a cashier's check, I believe, from the bank.
Yes, sir.
And send it certified mail, return receipt requested with a signature showing you received it. So it has a little bit more tracking.
Yes,
So-
absolutely.
So let me get you on a breakout room so you two can talk real quick, very respectfully one another. Provide her a PO box or a mailing address so she knows where to send it directly. Then once
Okay.
you're in the breakout room, you are more than welcome to leave the court setting from there. Okay.
Thank you
Thank
again,
you,
Your
Your
Honor.
Honor.
Thank you.
Hello, Your Honor. Christine is, okay.
Stop.
Okay.
Under Texas Secretary of State rules, you are operating under LLC. You are required to credit and debit any and all business expenses related to your business services through an authorized account, not an individual account. You're not working as a DBA, doing business as a private individual. You're doing business as a cleaning service under the LLC rules. I guarantee The cops are not that hot in jail, ma'am. If y'all want to go to jail under tax fraud or any kind of other fraud, operating a business like that. So provide her the information needed in reference to the business address, and you deal with the banking issue there. You
Okay.
understand?
No worries.
All right, I'll put you back in the breakout room, provide her that information, and you just take care of it that way, ma'am.
And
Okay,
Your Honor, I have one more question.
Yes, ma'am.
The mail that I have already sent, certified mail, she's providing me with a different address. Is that okay?
If that's the address she wants it to go to, then that's the address that it will get to. If it's returned to you, ma'am, you're showing it due diligence, you're trying to satisfy the debt.
Okay.
But until she receives it and sends us a notice that it's been satisfied, we cannot remove it from the judgment until that time. Okay?
Yes, sir. Thank you.
Sir, I had one more question before you go, please.
Yes, McGee.
So the issue is the there was a mistake that an accountant made, and the LLC, we owe a lot of money in taxes. That is all within legalities, and it's been taken care of. That there is no more LLC. So it has to be sent to Carrington McGee, which is why we filed under my personal name. We didn't file as Annie's Cleaning Service.
Annie's Cleaning Service. So did you just commit fraud to my court, ma'am?
No, my office manager may have put the wrong name on there, but it was supposed to be filed as my first and last name.
No, ma'am, it's filed as
Carrington.
Annie's Cleaning Service LLC. So did you commit fraud by filing a fraudulent petition with my court?
No, I think my office manager is the one who filed it. She got confused when filling it out, and it was supposed to be filer name, which is Carrington McGee. We weren't filing as the business. If she sends it to as Annie's Cleaning Services as the payer, I won't be able to cash it because until the tax issue is resolved, it's a 5-year plan. Until it's resolved, we cannot resubmit to reinstate the LLC. And I can show proof of all of this. Everything is legally where it's supposed to be.
I am very familiar with LLCs under the state of Texas, but it has a Carrie McGee Annie's Cleaning Service LLC plaintiffs. So
Right, as Carrington
as an LLC, then that's the way it's going to be entered into the case today, ma'am.
Even though it says Carrington McGee at the beginning.
You filed it as a business suit. You are the agent for that business, ma'am. So that's why I was listed as Annie's Cleaning Service LLC.
And
So
there's no.
If you want to go back into the breakout room and talk to this young lady and work something out with her on a different spectrum, you're more than welcome to go back in there and do that. Otherwise, I'll bring you back into court or I'll make some decisions here this afternoon. If you filed fraudulently that you did not have an LLC at the time that this case was filed, I will go and look under the rules. At the time of services, if you are working as an LLC, that could be a little bit different. But
The name of, we're not claiming we have an LLC. The name of the business is legally Annie's Cleaning Services LLC with the IRS. That is why that was put on there. Not that we're claiming we're an LLC.
y'all go into the breakout room and talk a little bit more.
Okay, sounds good.
Bring up under the Secretary of State.
In the end, the judge ruled in favor of the cleaning company, finding that services were provided and that the customer had agreed to the company's written policies. However, the hearing didn't end there. Questions about the business's legal status and payment process created an unexpected twist before the case wrapped up. It's a reminder that in civil court, contracts, paperwork, and clear records can be just as important as the work itself. If you enjoyed this courtroom breakdown, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom drama and legal analysis.